All right, we're live on YouTube.
Good afternoon. I'd like to call to order the March 15th, 2021 meeting of the Town of Kiawah Island Board of Zoning Appeals. I'm Frank Cassidy, the chairman of the board. Note that this and all our other committee and public meetings are being held over video conference and are streamed to the town's YouTube channel. Members of the public wishing to submit comments regarding any of the presented BZA cases should email their comments to Petra Reynolds, town clerk, at preynolds@kiawahisland.org. The board members who will hear your case today is Wendy Kulik with us, John?
Wendy will not be joining us today.
Okay. So myself, Frank Cassidy, Jay Lewis, Morris Hannon, Russ Berta, and Larry Rosenfeld. And staff members present here are John Taylor Jr. and Joe Wilson, our attorney. Our case rulings for this and any BZA meeting are available for public review and inspection during normal business hours at the town hall. Since our meeting is being conducted virtually via Zoom, please be reminded that in order to obtain a clean and clear record, for persons listening live, it's important that all participants not speak over one another. It's also important that we put our computers on mute when we're not speaking. If you'd like to speak, please do so by raising your hand and wait until I acknowledge you. I'd like to ask any members of the public who are with us here today, if you're familiar with the procedural workings of the BZA. If everyone is familiar, I'll skip the comprehensive explanation. Anyone like to hear that comprehensive explanation? Seeing none, we'll continue. Because today's hearing is a public fact-finding meeting, we are in compliance with the Freedom of Information Act and SC Code 6-29-70. This is a quasi-judicial body. Everything said in this meeting must be complete, true, and accurate. All of the information provided to the BZA is considered evidence, and this board may certify contempt of circuit court if false statements are made, either in writing or orally. Because of this, each person who wishes to address the board will be sworn in. In order to expedite that procedure, I'd ask those wishing to speak at this hearing to raise your hand, and Mr. Wilson will administer the oath.
Okay, for everyone giving testimony, please repeat after me. Do you affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God? Or just say, I do.
I do.
Thank you, everybody. I'll now call the case BZA 21-000003 at 4161 Summer Duck Way. Staff will present the facts pertinent to the case, and I'll then call on the applicant to address the case. The applicant, I'd ask to state your name and current address for the record before presenting testimony. I'll then ask any others who wish to speak either in support of or opposed to the case to speak, and they'll be limited to 2 minutes, and I'd ask them to identify themselves as well. And the applicant will have 2 minutes for rebuttal. Okay, John, we can start.
Thank you, Mr. Cassidy. Today's case, this is case application BZA 21-000003. This is a variance request for the reduction of the required 7-foot side setback, and this is for approximately 20 square feet of encroachment for a proposed rear addition. The applicant is being represented by Ms. Kava Compton, who's representing the property owner, Joseph Aiken. Subject property is 4161 Summer Duck Way, TMS number 209-0600-065. This subject property is located in the R20 overlay zoning district within the developed lands. It's approximately 6,331 square feet in size. and the existing residence was constructed in 1979 per Charleston County records. This subject property is also under the purview of the Architectural Review Board. The ordinance does require that there's a 7-foot side setback on this particular lot. That would include 20 feet in the front and 15 in the rear. Here's a subject property as stated, zone R2O in the overlay zoning district. And the applicant's application today, as stated, is proposing to add a rear addition to the home, and approximately 90 square feet addition, where approximately 20 square feet of that sits beyond the side setback. Here's just a few images that are of the site that I took here towards the rear and across Summer Duck. Here you see the encroachment of the side setback, and at this time I'll review staff findings based on the criteria of approval. And so it should be noted regarding criteria 1 or criteria A, extraordinary and exceptional conditions. There may be extraordinary and exceptional conditions, and this is due to the required setbacks in addition to the existing encroachment making an illegal non-conforming structure. There are a number of trees on the existing property as well. Additionally, the structure was established in 1979 prior to the setbacks being established per the zoning ordinance. The applicant has also stated that, quote, they've looked to positioning the addition within the setback by extending the house towards the rear. However, that was due to location of a grand tree in the area. Criteria B, these conditions may be unique to the subject property and may not have generally applied to other properties in the vicinity. Subject property is located in the R2O zoning district, and existing structures may have similar encroachments. Criteria C, the application of the ordinance to this particular property of 4161 Summer Duck Way. This would prohibit the construction of the addition as both the existing house and the proposed modifications encroach into the side setback of 7 feet that's required. However, it does not unreasonably restrict the utilization of the property. Criteria D, the authorization of this variance may not be of substantial detriment to the adjacent properties with an existing rear lot side setback. Encroachment. The proposed modifications increase the approximately by 20 square feet, and the existing structure is already approximately 4 feet 6 inches from the property line, and the proposed modifications would increase that to decrease the distance to approximately 4 feet 2 inches, and that's at the furthest eastern point of the addition. The applicant has also stated within their letter of intent that the house currently sits beyond the left side setback and would be increasing the existing area of encroachment with the addition, and just general distance of a setback from the structure and adjacent. They don't feel that this encroachment would be detrimental to the adjacent property. Criteria E, regarding this application, granting the variance would not allow the establishment of a use not otherwise permitted in this particular zoning district. Criteria F, BZA may not consider profitability considering this request. And criteria G, the need for the variance may be the results of the applicant's own actions. However, per the applicant's letter of intent, they've looked at positioning this addition elsewhere, and due to the location of a grand tree in that area, it does not seem that that's a viable option. This would also alter the buildings in such a way that would no longer be consistent with other homes in the regime. Criteria H, the granting of variance may not be contrary to the public. This particular variance request was reviewed by the Architectural Review Board, and the Architectural Review Board did grant approval, stating that the variance to build an addition over the side yard setback is approved given the home was already built over the setback, and therefore the completion of the footprint should have minimal effect on the neighboring property. And then also the applicant has provided correspondence from the Night Heron Board of Directors regime, saying that they had no issues with the owner requesting a variance for this particular request or addition. And the final criteria I that speaks to the comprehensive plan and the purpose of the ordinance, staff's response granting of the variance may not substantially conflict with those two documents. And so regarding the Board of Zoning Appeals decision, you may approve with conditions, or deny. And this is in respect to the request at 4161 Summer Duck Way regarding approximately 20 square feet addition or encroachment rather beyond the side setback. That's all I have regarding this particular application. I'll entertain any questions that there may be.
Any questions for John?
Yes. John? Larry?
Hey.
How far did you say the 7 foot would be reduced by this thing, to 4 foot something?
So the existing encroachment right now at its furthest point is about 4.5 feet.
Right.
That would be would encroach to about 4 feet 2 inches now with the addition. So it's a difference roughly about, to me as staff, would be sort of unnoticeable in the field, if you will.
Only because it's, it's just that short section.
Correct.
Has anyone heard from the neighbor on the, I guess, west side, the south side, whatever it is?
We did get a phone call from the neighbors. I provided the information for them, and I didn't hear back whether or not they wanted to provide any additional comments. I gave them that opportunity to provide comments in writing to the board, but I have not heard anything in favor or opposition of that particular. They just wanted to know what the request was for. I provided that information, and I have not heard back. I sent the details for today's meeting that they may join if they're able to, but I have not heard back from that particular neighbor.
Okay, and one more thing, since I'm new to the board, I don't know, do we have a history where existing homes that preceded the zoning setback rules are then allowed to further encroach, or do we, what is the history of the board, out of curiosity? Or is it still on a 1-by-1 case, which I know it's supposed to be? But if the house already encroaches, don't you feel that you're exacerbating the situation?
So you're right that each case will be treated individually, and each case is treated on its own merit. So there isn't sort of a precedent to look at former cases of similar encroachments of this type. I would state that the town, or Kiowa, does have a number of properties that were platted prior to setbacks going in. And so there are a number of cases where existing residents' setbacks are through the middle of the house or through a portion of the house. And so it isn't uncommon to find that. So we've had variances for that particular reason come before the board because of that nuance.
Thank you.
Any other questions? Okay, Ms. Compton, would you care to make some comments?
Hi, yes, thank you. My name is Cava Compton, and I appreciate you hearing the case. That all sounded very accurate. I just wanted to kind of hone in on a couple things. First and foremost, I've realized that this survey that we've provided I believe has the eaves marked on it rather than the building footprint. So if that is the case, those eaves are 2'6" deep. So my existing encroachment to the actual building structure versus the eave, the siding, so to speak, or the band, I think actually I'm just encroaching about 2 inches on the existing back corner of the house. And so that encroachment is probably going to grow to about 5 inches as you get to the outer corner. So I think my actual encroachment is going to be less than 2 square feet, but I want to confirm that before stating that. But the worst case scenario would be, under a 20, slightly under a 20-foot encroachment. And then I just wanted to point out, it is in the Night Heron neighborhood. A lot of homes have done this same renovation, which is basically just infilling the backside of that footprint. And as far as I know, that is the only additions that Night Heron allows or approves. So a lot of people have turned where mine is showing an orange deck. Some people have turned that into living space or whatnot, but basically the only thing they really allow is basically an addition that completes the box of the house, so to speak. And I think that is it.
Let me just understand what you said about the encroachment. So what is it? The roof line extends over much further than the actual building itself?
Yes. When we're looking at this survey and the back corner of the back corner of the existing house, it says it's 4 foot. I believe it says 4 foot 4 inches. I'm having trouble reading it on my screen. I have a paper copy here. Yeah, it says it's 4 foot 4 inches. Once I add my 2'6" if I come back 2'6", the corner of that building that reads is 4'4". The corner of the eave is really 6'10" from the property line on a 7-foot setback,
Okay,
if that makes sense.
it does.
Could I, just as a moment, well, after you're done, I maybe want to just clarify something with Joe on that, just based on that information. So I'll let you finish your comments there, Mr. Chairman, or the public comment period. But before you all take action, I want to just clarify something.
Okay. Did you have anything else, Ms. Compton?
No, sir.
Is there anyone else who wishes to speak, or are there any other questions?
I think John's going to ask the question I have. Is the zoning the footprint that actually touches the ground, or could it be the eaves? If the eaves overhang, yet the structure itself is within the setbacks, is that a violation?
So that's what I wanted to ask Joe about just procedurally how to maybe move forward on this. That would let me just clarify what the ordinance says, and then we can go there. So the ordinance does allow eaves to encroach 2 feet into the setback. So that would only that's built into the ordinance. So that isn't a purview of the BZA. That can be done administratively if there's an application that comes before for review. If there is the building structure meets the setbacks, however the eaves extend over that setback line, they're granted a 2 feet sort of grace to go beyond that setback. My question is for Joe, since that changes somewhat the review of this particular case, can we still move forward by a particular action? I don't want to necessarily rehear the case, but on that particular new fact that the survey that's part of this application, it's reading as not 20 square feet being added in this case.
If everyone's amenable to it, I think we can continue.
Okay.
So is it just the magnitude of the variance is different now? It's not 20 square feet, but less?
Correct. That. So it would be less of an encroachment from my understanding as staff based on that nuance of this survey not being the footprint of the structure, but just a portion of the eaves.
But it's still an encroachment that requires BZA approval.
Correct,
Okay.
right?
Just
It's
for
still, it's
clarification, too.
just less.
Just for clarification for me, the actual footprint setback that's on the ground is less than a foot? Is that what we're saying?
Ms. Compton?
So when I was reviewing this right before the meeting, it just kind of caught my attention. And I was going, you know what? I don't know that that's what this surveyor shot back in the day. This is an older survey that I had a copy of. I wasn't certain whether they shot from the eaves or whether they shot from the sides of the buildings. The house is on elevated piers, so I don't think they would typically shoot off the piers. Usually they'll shoot off the band of the house, that tells you about where but sometimes they will shoot off the eaves. And unfortunately, the surveyor did not document what he shot on this page. But when I started looking at it, it made sense to me that, yes, I think maybe they shot the eaves here. And if that's the case, my eave is about the end of my eave would be 6'10" from the property line, which I know we would still need a 7-foot encroachment.
So you think the eve is 2 inches over? Is that what you're saying?
I think the actual body of my building is about 2 inches over the setback line.
Okay.
At this back corner of the house, existing back corner.
Okay.
One more question,
Yes, sir.
Ms. Compton. The house you said is up on piers. Any of the piers being moved or any new ones being added? Or is that footprint going to stay exactly the same?
We would need to add another, they're actually the wood driven pilings. And we
Yes.
would need to add one more piling on the back corner of the new addition.
So the piling would be technically outside the line of the zoning.
It would be inside the line of my addition.
So it's a non-issue is what you're saying.
Yes,
Yeah.
yeah. That
Yeah, I
piling
walked
would
the
be
site
inside.
yesterday. It will be, the piling will be within the setback. I walked the site yesterday.
The piling could will probably be within, beyond the 7-foot setback. It'll probably be legal, but
Yeah.
I can't clarify that for sure right at this moment, but it would be within the, confines of the addition. It would tuck up underneath our addition.
Yeah,
So
the
would be
piling
consistent
is
with the
offset from
addition.
the perimeter of the house. It would, I looked at it, I'm pretty sure it'll be fine. Piling will be.
Any other questions or comments? I'd entertain a motion if someone would care to make one.
I'll make a
I'd like to make-
motion that we approve.
I second that.
Thank you. Any further discussion? Hearing none, I'll call the roll and ask everyone to vote. Jay Lewis,
Yes.
Morris Hannon,
Yes.
Russ Berner,
Yes,
Larry Rosenfeld,
Yes.
and Frank Cassidy, yes. So the motion is approved. It's approved because it's a very minimal effect on the neighbors. It's a very minimal encroachment, and the neighborhood association has no issue with it, and it's been done at numerous other houses in the neighborhood. I think that's, John, do we have any other business to attend to today?
I don't have any other business for you all. This Friday will be our deadline for the next month's agenda, so I will have information by Friday if we will have an April meeting.
Okay, thank you, John.
Just one
Ident-
other note, I think,
Sure.
just to be sure, to Mr. Wilson, does that cover our bases? You think that we're good as far as what transpired for the record?
Yes, I do.
Okay. All right. Thank you. That was all.
I think it's fine.
All right,
Thanks,
thanks,
guys.
everybody. We stand adjourned.